So, without any further ado, my name's Anna Govan and I am Chief Executive of Tide and also Life Story Network. And I'm absolutely delighted to welcome you on this webinar this afternoon. It's very exciting. We've had over 220 plus applicants for the webinar, which is the biggest we've had to date. So it's incredibly ambitious to manage this. What I'd like to do is tell you a little bit about the project, but before I do so, I want to introduce the key people on the call who are supporting the work today. So I'm going to go to Neil first.
Good afternoon, everyone. My name's Neil Allen. I'm a lecturer at the University of Manchester, where we run the Justice Hub and provide a dementia law clinic with free legal advice. And I'm also a barrister working mainly in the Court of Protection. And I'm going to go through with you some of the legal issues regarding dementia care this afternoon.
Okay, and Peter, I'm going to go to you next.
Hi, good afternoon, everyone. And as Anna said, an absolute pleasure to spend some time with you this afternoon talking about those really important issues that affect all of you as carers. I'm the Executive Director for Quality and Compliance at a national charity called Making Space. We started in 1982 with a real strong passion to supporting people with mental health issues and family carers. We've expanded our beneficiary group. That passion is still there. So I'm really looking forward to listening to the things that you want to explore today. And I'm looking forward to the next session together. So thank you very much.
Okay, Kath, I'm going to go to you next, and then Karen and Rebecca and Lena, and then I'll carry on. Kath, do you want to unmute yourself?
Good afternoon, everyone. My name is Kath Penrith. I work with Peter at Making Space, and my role is Consultant Admiral Nurse. So I work across our services supporting any families where someone's experiencing dementia. I've got about 23 years experience working in this field. So I've been having some lengthy conversations for quite a while now with Anna about how we can explore legal issues that families face. And that comes from my experiences of talking with families. So what I'm going to do during this session is I will keep tabs on the chat box, and anywhere where anything crops up where I can maybe signpost you or follow it up afterwards with an email, I'll make a note of it, so we will follow it up. Okay.
Okay, and Karen?
Good afternoon, everyone. I'm Project Manager for the Law for Dementia Carers project, which is funded by the Legal Education Foundation. It's a 2-year project, started in November last year and runs until October 2021. Really excited to see so many people here today, because I think this is such an important issue for carers. I have a background in adult social care and also a carer myself, so thank you very much for coming today.
Okay, and Lena and Rebecca.
Hi everyone, I'm Lena. I work at Tide as an impact reporting manager, and I support the evaluation of the Law for Dementia Carers project. So welcome everyone.
Okay, and Rebecca.
Hi everyone, my name's Rebecca. I'm the admin officer for Tide. I'm here for a bit of tech support, so if anyone has a question, I'll be monitoring the chat box as well.
Okay, now what I'm going to do is just briefly give you an overview to the background of this project and take you through some of the etiquette in terms of organising or facilitating a Zoom call, because it's still early days for everybody doing Zoom calls, so there's just things that to help the smooth running of the session. So just in terms of the actual background to this, the webinar, as Karen said, is part of the Legal Education Foundation, and it really builds on some conversations that we've been having for many years from people with dementia and carers around the difficulties that they have in terms of accessing legal, social welfare and human rights support. Now, we know that there's 750,000 carers of people with dementia across the UK, contributing 13.9 billion a year to the care economy. So clearly the care economy would completely implode if it wasn't for your contribution to it. But I think what we're finding is that you're very poorly served, and there's not really one place to go in terms of looking at what your needs are from a welfare, a legal, and in particular, a human rights-based approach. And the reason we wanted to get this funding from the Legal Education Foundation is that the whole philosophy around TIDE is to get carers connecting with each other. So it's great to have 220 almost on the call today, but also to ensure that you're well informed about what your rights are, whether they're welfare, whether legal, or whether they're human rights. And therefore, it's much more empowering then for you to have those conversations around advocating for yourself, but also the person that you're caring for. Now, obviously, we've all been thrown into a bit of an abyss with the COVID-19 pandemic. But what's really been important and what's come through is the fact that the emergency legislation was rushed through. So the COVID-19 2020 Act was rushed through in a matter of 4 days by the UK or by the England Parliament, and subsequently by other parliaments across the 4 nations. Now, whilst we understand the rationale for that in terms of making it easier for local economies to address the challenges that we all face as a result of COVID, clearly there are significant implications for carers and people living with dementia, and that's part of what we want to discuss today. So what we're going to be doing is we're going to try and cover, we've already had 60, I think, or 70 questions pre-submitted, but we're going to cover areas around early diagnosis of a cared person, your caring role, the cared for person's best interests, and residential care and end-of-life care. We're going to try and spend about 15 minutes on each topic with some opportunities for questions and comments. And you'll see in the bottom of your screen, if you run along the bottom of your screen, there's a chat box. So if you open up chat, if you haven't already opened it, that means you can pose some questions or some issues that you want to discuss within the group on the chat. So already we're seeing people coming through from various places. It would be good actually just to get an idea from you all as to where you've joined from. I see somebody from South Wales, I see somebody from Durham, Dudley, Hereford, Herefordshire, Wales again. So if you could just pop on there where you're from, that would help us just to get a sense of the spread of the people that are joining us today. Also, just in terms of other things to ease the facilitation of the session, if you're having problems hearing anything, if you turn off your video, that can sometimes improve the connection. But equally, if you don't wish to be seen, or you don't wish to have the inside of your living room being seen, then you can equally feel free to turn off your video. The other things just to say is that if you want to ask a question, if you press on participants at the bottom of your screen, then another part of the screen will open up, and there's a blue hand which you can raise your blue hand, and then we can keep a note of people wanting to ask questions and bring you in. Rebecca and Lena will keep an eye on that and ensure that you are included in the conversation when we open it up for questions. I'm just trying to think, is there anything else that we need to... so we've got an hour and a half, so we're due to finish at 5:30. And so what we'll do is I'm going to hand over to Neil just to go through the format of the key things that's come through already around those 4 areas, and we can start to explore some of that. There will be some time for questions, and I'll try and keep an eye on time to ensure that we keep the conversation flowing. Neil, I'll hand over to you.
Thanks very much, Anna. So just to explain how today has all come about, we've been receiving a lot of questions through TIDE, Making Space, and at the university from those who look after people with dementia. We've had well over 60 queries, and what we've been doing is at the university we've been running a summer school last week remotely, keeping a safe social distance, during which we've had undergraduate law students look at the questions that many of you have been asking. And we've divided those questions into 4 main areas, which you can see here. So dealing, first of all, with issues around early diagnosis for a cared for person. Secondly, looking at the caring role and the sorts of issues that arise in relation to that. Thirdly, best interests. If someone has lost capacity to make their own decisions because of dementia, where do we stand when it comes to determining their best interests, and what if there is a dispute between decision makers? And then finally, a big topic of residential care and end-of-life care. You'll have seen in the news that there's been a lot of concern around things like do not attempt resuscitation orders. So those are the 4 main areas that we're going to cover. It's worth me emphasizing that nothing that I say and nothing that the students will be saying to you this afternoon constitutes legal advice. Okay, what we're sharing with you is not advice on particular scenarios. What we're providing is general information about the issues. But if after today you do need any specific legal advice, then by all means get in touch with us, and we might be able to help through our Dementia Law Clinic at the University of Manchester. Right, so with all that in mind, let's start off by looking at the first issue of early diagnosis for a cared for person. And I'm going to hand over, all being well, to Rafiat, who's going to talk about mental incapacity. Rafiat, over to you.
Okay, thanks, Neil. So essentially what mental incapacity is when a person is unable to make a decision because of, for example, their dementia. But first we have to look at a few principles which are included in mental incapacity. So firstly, a person is assumed to have capacity unless proven otherwise. Secondly, all practical steps must be taken to help them make the decision. And thirdly, an unwise decision does not necessarily mean that a person lacks capacity to make it. And these principles are put in place to ensure that the well-being of those who are being cared for is protected at all times.
Sorry, Rafiat, that's my mistake. Okay.
No. Second, we'll look at what a decision actually is, and there are 3 things to take into consideration. So a person should be able to understand, and then they should be able to retain, and finally they should be able to use and weigh up that information or communicate their views when making a decision.
Thanks ever so much. So the kinds of questions that we've had relating to mental capacity concern things like whether someone is able to understand the need for social distancing. One person asked, what do you do when you're looking after someone with dementia? And usually they could be supported to go outside, but they don't understand the risks from the pandemic. And what do you need to do in that sort of situation? And so far as the law is concerned, and today we're really focusing on the Mental Capacity Act from 2005, as well as the Care Act from 2014. Mental capacity, as Rafiat was saying, is very specific to a particular decision. So it's entirely logical that someone with dementia may be able to make some decisions, but not others. And so when it comes to things like going out, we need to think about, okay, well, what is the information that's relevant when I decide to go outside of my home? Obviously, part of that decision is being aware of the risk of contracting a virus that could potentially be deadly, and the potential ways in which that risk could be mitigated by keeping a safe distance. And I didn't see the news this afternoon, but I understand from reports that it's now come down to a 1 meter or so distance. So it's important whenever anyone, whether it's someone with dementia or not, is making a decision to go out, they're able to understand the risks of contracting the virus, that they can retain that information when they're deciding to go out, and that they can use that information, they can weigh it up when thinking about whether to go outside. And if it is the case, let's say the dementia is so advanced that they're unable to grasp that information, then it will be that they lack capacity to make that decision. And then as a carer, we are into the realms of best interests. Now, of course, best interests, as we'll see later, does not necessarily mean that the person won't go out. But what it does mean is that others, typically the carer on the ground, will be there to decide whether going out and how to go out, where to go out, whether that is in the person's best interests. So that is essentially what mental incapacity means in law. And the assumption of capacity is crucial because that is aimed to prevent discrimination. So even if I've got dementia, our starting point is always to assume that I am perfectly able to make my own decisions, unless others can show and reasonably believe that I can't. The other topic that has arisen with regards to decision-making at the early stage is around deprivation of assets and care home fees. We're going to come back to this when we look at the fourth topic of residential care. But quite often, people ask about to what extent, in essence, can someone give away their assets, give away their estate, give away their property, whether that's to take into account inheritance tax or to take into account potential social care fees. Because it's worth us saying right at the outset that, and this is very controversial, and many of you who have asked questions have raised this issue, it's worth saying at the outset that in England and Wales, if you are talking about social care funding, that's means tested. So we'll look at what the financial thresholds are later on. But essentially, we have a divide in English law between social care and health care. And social care is means tested. In other words, if you've got the financial means to pay for your social care, then you're expected to do so. Whereas healthcare is free at the point of need. And so there are legal provisions in place to try and minimize the risk of us all getting rid of our assets simply to be able to get free care home placements. So let me just talk you through this for a moment. So deprivation of assets, this is sort of defined as where a person tries to deliberately, and that's really critical, it's where you deliberately avoid paying for care and support costs by getting rid of your assets, whether that's your capital or your income. And the reason it's important is because if your assets fall below £23,250, then you could become eligible, you could become entitled to at least a contribution towards your social care costs. But if a local authority is able to show, and it's for the local authority to prove this, if they can prove that you have deliberately got rid of your assets to fall below that threshold of £23,250, then either they can charge you as if you had the assets, or they can seek to recover that money back so as to require you to pay for your social care. The key issue, and this is what local authorities will be focusing on, is whether or not the deprivation of assets, the giving away of your estate, was deliberate at a time when you knew that you had need for social care. And so these are the sort of three things that they will be looking at. Firstly, the motive or the intention behind the disposal. Why was it that you gave away your money? Could it be shown that this was to avoid care home costs? Secondly, when did you get rid of your money? What's the timing of your disposal? How long did you get rid of it before you required social care, and they'll also take into account the amount of money that was given away. And ultimately, if they can prove, and it's not often easy to do this, but if they can prove that your assets were given away to deliberately avoid the cost of social care, then they can recoup that money. So it's very important, therefore, for someone who is showing signs of dementia, and in fact, it's important for all of us, for that matter, to think about our estate when we are making decisions for the future. So that's deprivation of assets. He says, trying to move on. There we go. Okay, so that's our first topic of early diagnosis for a cared for person. Would anyone like to raise their hand to ask any questions at this stage? Sherry's got her hand up. Sherry, do you want to unmute yourself and ask your question? Sherry Wakefield?
Yep. My question is, you say about getting rid of your assets deliberately, but what if you were to just give your grandchildren and daughter gifts throughout the year? What is that classed as? Is that a deprivation even though you've still got quite a large sum of money in the bank?
No, that could well be seen as a gift. You're entitled, I think, to give away £3,000 per person per year. And so that could well be seen as a gift, and it may be difficult, therefore, for a local authority to show that you were deliberately trying to get below that threshold. Whereas if you give your grandchildren your house 2 months before going into a care home, then obviously the picture looks very different. But yeah, gifts up to about, I think it's £3,000 a year are perfectly legitimate and wouldn't fall into deprivation of assets usually. Thank you.
That's fine. And then just one other quick question, if you don't mind.
Yes, of course.
So with the power of attorney, I got power of attorney for my father 6 years ago. But how do you know when that power of attorney clicks in? Because he's still, well, things have changed slightly, but up until 2 months ago, he still had capacity to make those decisions.
Which type of power of attorney do you have?
I've just got the
Sorry, Sherry, can you say that again?
Yeah, I've just got the power of attorney for finances. I don't have the health.
Okay. Well, we'll talk a bit about powers of attorney in a bit more detail later on, but just for now, the time that power is triggered is different depending on whether it's for property and affairs or health and welfare. So I know you don't have the health and welfare one, but the health and welfare one can only be used once the person has lost capacity to make a particular decision. Whereas the property and affairs one is different. So that can be used even whilst the person has capacity to make financial decisions, so long as you're acting in accordance with what they want. So for example, I was appointed as a lasting power of attorney for my gran while she had capacity. It was soon after she had been diagnosed with dementia. And she was still able at that stage, at the beginning at least, to make financial decisions. And so because she was in a care home and unable to go to the bank and pay her bills, I was able to effectively carry out her decisions, if that makes sense. So if the person you're an attorney for still has capacity to make financial decisions, then you can use your power to implement those decisions. You can't go against what they want, of course, but you can use your power to implement their decisions. And once they've lost capacity, then of course, then you can make best interest decisions for them.
Okay. So I'm well within my rights. If my dad said to me he wanted to give one of his grandchildren £500, I can go get it out for him. That's perfectly okay.
If he's got capacity, then it's his decision.
Yeah, that's fine. That's lovely.
All right. Thanks, Sherry. Over to Jill. Jill Mason. Do you want to unmute yourself? There should be a button near the bottom left-hand side, I think, Jill. That's it.
I am unmuted, yeah?
Yep.
Okay. A friend of mine, his father was taken ill towards the start of the COVID thing and was in and out of hospital and has been placed in a care home because they feel that he's unfit to go home at the moment. And he had a conservatory built last year prior to him feeling unwell, was intending to stay at home. And now social services are saying that he purposely used that money so that it took him below the limit. What would you advise?
You probably want to see a lawyer, I would have thought, in that situation. As I say, the burden is on the local authority to prove his state of mind at the time. And as I say, this isn't legal advice. I can't give legal advice, but what the sort of issues would be, how foreseeable, how likely was it, to what extent could he foresee that he might need to go into a care home or might need social care at the time he decided to have a conservatory built?
Yeah, it was unforeseen.
So, you know, it may well be, without giving you any advice, but it may well be difficult in that sort of situation for a local authority to show and prove that at the time he was deliberately trying to get below his threshold rather than buying a conservatory. But as I say, if you are in dispute with the local authority, then it may well be worth coming to our dementia law clinic, because we can provide you with more detailed free legal advice.
Okay, I had no intention of asking this question, but
that's okay. Have you got any more, Jill?
Well, it's just that because this has happened, he also can't go and see his father. He can't discuss it with him. He hasn't seen him, and the whole thing has just escalated. And I just suggested to him that you just say, look, in these times, can we deal with this a bit later? Because this is, and it was 1 year since his wife died. So it's,
oh dear.
Anyway.
But yeah, let us know if we can help any more. Okay.
I will, as long as I've got your details, yeah.
Okay, thanks, Jill.
Thank you.
Hazel Barrow, do you want to unmute yourself, Hazel?
Okay. My issue is my husband's got advanced dementia now. We are under the 23.5 threshold. I get 16 hours funding from social services for carers during the week. I have a carer that is willing to work full-time in the house, which would be cheaper for social services, but they're saying, no, if he needs any more, he's got to go to residential care. And they're also saying that my contribution would be both his pensions, which is what we live on, and I would have to claim universal credit.
Okay, well, we're going to talk about someone's needs and how they are assessed, and local authority funding in the, I think it's the next topic, the caring role. But I think the key thing to sort of pin on the wall, as it were, is what you were saying about how full-time care at home would be cheaper. Because as we'll see, after someone's needs have been assessed, a local authority has to ensure that arrangements are in place to meet that person's needs, but they can take into account how much it costs. And so to put it quite brutally, if someone's needs could be met for less in a care home than in their own home, then that's where you often get into a dispute with the local authority. But from what you were saying, it sounds as though care in the family home would be cheaper than residential care. Is that right?
It would, yeah. I've got, well, it was his first carer that we had 3 years ago, and she would be willing for £1,500 a month to come and live in and help me out with him to keep him at home. his advance statement that we did 3 years ago says he wants to stay in the home.
Right. Well, £1,500 a month is a bargain from my experience. So if money is not the issue, then all I can think is that the local authority must be arguing that it's not in his best interests, or staying at home would not meet his needs.
Right, they've not been to assess him.
Right, well, if they've not assessed him, how on earth can they form a view? Right, okay, so well, I will cover that in more detail.
Brilliant.
Hazel.
Okay,
All right.
thank you. Yeah.
Thank you. Tracy? Do you want to unmute yourself? There we go.
Hi there. My question was, you said to sort out the finances early on. In terms of the depreciation of assets, how over what period of time are you being checked for? Is it from the moment of diagnosis?
No, you'll receive a financial assessment at the time the local authority is having to work out whether you need to contribute towards your care costs. Mm-hmm. So if I'll put it this way, like my mum at the moment, she's 74 now. And one of the issues for her is what to do with her house. She never wants to go into a care home. She doesn't have any symptoms of dementia or anything like that. But obviously she's thinking ahead and planning ahead. And so in that sort of situation, if someone gifts or transfers their assets, and then let's say, for argument's sake, in 5 years' time, we are now looking at someone with dementia, and we're looking at social care needs and funding, the financial assessment would be done at that point in 5 years' time. Mm-hmm. And they would look back to now, let's say, when money was transferred or given away, to try and work out, well, at the time that money was given away, did she reasonably believe that she would need social care? Okay. So the financial assessment is done at the point when we're looking at the care arrangements that someone needs, and basically who's going to pay for it. Is it the person or the local authority?
Okay, thank you.
Okay, thanks, Tracy. I'll just take one more. So forgive me, Beth, but by all means, put your question in the chat function. So Kate, would you like to unmute yourself?
I think you've kind of just answered it a little bit.
Oh, wrong one.
But my question was, I work within the younger person's dementia, NHFT in Northamptonshire. I really wanted to know if they have a time scale that NCC, well, in my case, it would be NCC, can go back and look at somebody's financial dealings. I've been advised that it's 7 years, which is in line with the tax threshold, but I've also been advised that they can go back further if they have the need to. Is that correct?
There used to be a sort of what we would probably call in law a limitation period. There used to be a period beyond which they could not go back, but that's not the case any longer. So what I'll do is I'll just put in the chat function a link. There you go. I've just put it in the chat for you. That's a link to the legal guidance on all of this. And it covers charging and financial assessments. So I should warn you, it's a very lengthy document, but charging and financial assessments are all covered in section 8. And you'll see that there is no deadline beyond which they can't go. So it could be more than 6-7 years. But bear in mind that obviously the further back they go, the much harder it is for a local authority to prove what the person's state of mind was
at the time of giving that particular money away.
Absolutely. Yeah. You know, can you imagine how difficult it would be for you to prove
massively
that 5 years ago, when I decided to give X pounds to someone, that I believed at that point that I would need to go into a care home? You know, it's very difficult to prove.
Okay, thank you.
The older it is.
Thank you for that.
Okay, thanks, Kate. Okay, so thank you for those questions. And we'll move now on to the second issue, if I can get this working, which is the caring role. Let's see if this works. Okay. So I'm going to talk a little bit in a bit more detail about powers of attorney, lasting powers of attorney. There are, well, basically LPAs, as they call lasting powers of attorney, were created by the Mental Capacity Act. Before they were created, we had what was called an enduring power of attorney, an EPA. Now, we still have some old EPAs lying around, but since 2007, it's only been possible to set up an LPA. So that's what I'm going to focus on. And there are two types of LPA. So a lasting power of attorney is basically it's a legal way in which you can appoint someone that you trust to make decisions on your behalf. One is for health and welfare, the other is for property and financial affairs. And they are completely separate beasts. So it's always really important, both for you as an attorney, if you are one, but also for professionals to know exactly what type of LPA we're dealing with. Because if I've got a financial lasting power of attorney, then I don't have the power to make health and welfare decisions, okay? Because you're limited, if you like, to the power that you've been given by the person. Now, we're often asked, you know, how do I set up a lasting power of attorney for my relative? Which is a perfectly understandable question, but the key thing to note is that it would be for your relative to decide, okay, because this is their decision. If I've been diagnosed, let's say, with dementia, I've just been to a memory clinic, right, because this is typically how this arises. I've been to a memory clinic, I've received a diagnosis of dementia. It's for me to decide, not my wife or my children, it's for me to decide whether to set up a lasting power of attorney. This is only an option if I still have the mental capacity to make this decision. If it's too late, if I've lost capacity, forget LPAs. We are having to look at something quite different called deputyship, and we'll talk about that in more detail later. Okay, so LPAs are not something you can create for someone else. It's their decision. They have to decide whether they want to set it up, and you cannot force someone to set up a lasting power of attorney. If I did decide to set up a lasting power of attorney, and we're all being encouraged to do this, when you look at, we have well over 1.5 million LPAs registered, and you'll find that most of them have been registered by the elder proportion of the population, but we're all being encouraged to do this. If you do decide that this is something you want to do, then you need to choose carefully. You need to think about who you trust to make decisions for you in the event that you can't decide for yourself in relation to health and welfare in particular. And whether you have one person or more than one person. And as I've said there, if it's more than one person, at the bottom there, you should decide whether you want those people to have to agree unanimously, or whether you're happy for either one of them to make a decision for you. The vast majority of LPAs fall into the second category. In other words, most people, if they appoint more than one person, it tends to be on what's called a joint and several basis. In other words, either attorney could make the best interest decision. So in terms of the cost, if I can just get this to work, bear with me, there we go. Often, and some of you have asked, you know, do I need a solicitor? The short answer is not necessarily. This is something that you can do yourself. It very much depends on how complicated the power of attorney is going to be. So the cheapest cost, if you like, is £82 per LPA. There are some exemptions. So for people on certain benefits, for example, it doesn't even cost £82 to register an LPA, but that's the cost to register it with the Public Guardian. The Public Guardian has a fabulous website. If you just Google something like OPG or Office of the Public Guardian, it will take you there, and there's a lot of information there. That's where you can get hold of the forms. So you don't necessarily need a solicitor to do this, and obviously that would avoid legal costs if you didn't involve a solicitor. But sometimes it's wise to do so. So to use a personal example, after my gran was diagnosed with dementia, together we decided that it would be best to involve a solicitor because her dementia was apparent, and we wanted to make sure that the LPA was watertight in terms of no one being able to sort of challenge the validity of it. We didn't want us to be in a position later down the line when someone might turn around and say, well, hang on, how could she have capacity to set up the LPA given that she had dementia? And the fact that a solicitor was involved and certified that she knew what she was doing and was able to make the decision to create the LPA, we thought would be sensible. But obviously there were costs to that. So you don't have to involve a solicitor, but sometimes, depending on the situation, it might be wise or prudent to do so. The Public Guardian's website is absolutely fantastic. And the person that's creating the power will need to get that registered, will need to get it witnessed. Now, this can be quite difficult at the moment, although obviously it's a bit easier now with social distancing being eased. But on the Public Guardian's website, you'll find information about the practicalities of getting these documents signed and witnessed, bearing in mind the need for social distancing. That was particularly important when we were all in lockdown. But now that we can maintain a 1 meter distance, it's much easier to get an LPA witnessed and signed. It takes about 8 to 10 weeks usually between sending off all the forms, the Public Guardian going through them, making sure no one is objecting, and it being registered. And you can't use the power unless and until it's been registered. So that's the sort of time frame we would be looking at. And we've also included there the phone number for the Public Guardian if you need to get in contact with them for further details. Okay, deputyship. Deputyship is basically when it's too late for someone to set up a power of attorney. So if, let's say, someone with dementia does not want to set up a power of attorney, they can't be forced to do so. But let's imagine now that cognitively they've declined to a stage where they're now unable to manage their financial arrangements. But no one else has the power to do so. So let's imagine that, you know, you're not a joint account holder, so you don't have legal access to the bank account. Or maybe their house needs to be sold to pay for care home fees, you know, whatever the situation is. If they've lost financial capacity, the capacity to manage their finances, and if no one has the legal authority to act on their behalf, then we might be looking at deputyship. Now, this is quite a pain in practice because it means that you have to apply to the Court of Protection to become a deputy. The vast majority of deputies are financial. I would say roughly 85–90% of deputies are appointed to manage someone's finances. It's quite unusual to have a health and welfare deputy, in other words. But this is more complicated than a power of attorney because it means you're having to go to court. not necessarily physically, but on paper. You've got to make an application. There are court forms, there's evidence that's required. And ultimately, if the court agrees that it's in the incapacitated person's best interest to have a deputy, then you can be appointed. And who is appointed will very much depend upon the size of the estate and how much money we're talking about. So for relatively small sums, it's not unusual for a family member to be a financial deputy. Whereas for much larger sums, the court might be looking at a professional, like a solicitor or an accountant, to act as a professional deputy. And obviously they charge for those services. So deputyship is sometimes a necessity when they've lost capacity, but we've got no legal authority to manage the finances. But the process is not straightforward. This may well be a situation where you might need legal assistance with the forms and so on. So it's a more expensive process than lasting powers of attorney can be. As I say, deputies are very different to LPAs. Personal welfare ones are pretty rare. The reason the courts are sometimes reluctant to appoint a welfare deputy is, bear in mind that if you're a deputy, you are the decision maker. You have the legal right to make decisions for someone, in the same way as if you're an attorney under an LPA, you have the legal right to make the decision. And LPAs and deputies, they decide within their powers that have been given to them, whether that's by the person or the court. And if anyone wants to challenge that decision, ultimately they'll have to go to court. And that's important because some of you have asked about situations where you are the attorney, but you've not been asked for the decision, which is entirely wrong, because if there's a power of attorney in place or deputyship, you are the best interest decision maker. And if a social worker, a nurse, a doctor disagrees with your best interest decision, and if that can't be resolved by discussion, ultimately they can't just go against your view, they would have to challenge your decision in court. So that's deputyship in a nutshell. Even if there is a health and welfare deputy, they can't make life and death decisions like some attorneys can. And also deputies are more heavily regulated by the public guardians. So if you're a financial deputy, every year you have to provide a report to the public guardian that is like a set of accounts, really, that sets out how you've spent the person's money during the course of that year. Okay, I'm just going to move on quickly to the Care Act and assessing needs, which was touched on before. So local authorities must assess those who appear to require care and support, regardless of whether we're talking about self-funders or state-funded care. And what local authorities have to do, and this is all under the Care Act, is to decide what your needs are, and we all have needs. So what are your needs? But then critically, what needs are eligible for services, okay? Because ultimately the legal duty is to meet someone's assessed eligible needs. And often that's where there's a dispute as to whether this is a need that's actually eligible for local authority arranged services. So that's what they have to do. And unless the easements have been activated, and I'll say a bit more about this shortly, there's been no change in the law, okay? So local authorities still owe a duty to assess needs during the pandemic. And don't forget, we're not just talking about the needs of a cared for person, we're also talking about the carer's needs. And so when I talk about assessments, I'm talking about a needs assessment for the person that's being looked after, but also potentially an assessment for you as a carer as to what your needs are. Now, the law already allows local authorities to do this from a distance. So these assessments can be done by telephone or remotely through Skype or Zoom, whatever it might be. Sometimes local authorities might ask you to assess your own needs with what's called a self-supported assessment. But all of that can be done as the law stands. And it's important, this, because some of you, in advance of today's session, have been told, typically by a social worker, that your local authority are not doing carers assessments or needs assessments because of COVID-19 or because of easements. Now, that's likely to be untrue, because the last time I checked, there is only one local authority in England and Wales that have activated these easements. So before I talk about easements, let's have a look at this in a bit more depth. So a needs assessment, as I say, can be offered by phone or online if there are concerns, whether on your part or the assessor's part, about social distancing. If a local authority is delivering an assessment remotely, it's got to take into account the person's cognitive and communication needs as well as their capacity. And so far as a carer's assessment is concerned, if you feel as though you need your own care and support in your role as a carer, then you can request a carer's assessment. And we've just given some examples there of the sorts of benefits that you might receive depending on the outcome of the assessment. So having someone to take over so that you can take a break, gym memberships, although I don't think gyms are open yet, are they? Help with taxi fares if you don't drive, gardening, housework, training on how to live safely, so safe manual handling, putting you in touch with local support groups like Tide and Making Space, and giving you advice around benefits. So there are significant advantages to having a carer's assessment, and unless the local authority has triggered these so-called easements, then they're still legally obliged to undertake them. We've had quite a few questions around direct payments, and this is essentially what direct payments boil down to. If you or the person you're looking after have been assessed as needing social services support, you have the option of asking for a direct payment instead of receiving the support arranged by the council. So, you know, if you've got assessed eligible needs, either the local authority could try and make care arrangements, or an option they have is to basically give you money, a direct payment, so that you sort out those arrangements yourself. They don't have to provide a direct payment, but there is an expectation that in a suitable case, one would be offered. Obviously, you'd need to have an assessment from the local authority before receiving a direct payment, but if it's offered, then you can use that to basically commission the care and support that's required. And just one final thing about direct payments. If the person being assessed doesn't have capacity to manage a direct payment, then the local authority might appoint someone to manage it for them. So that's something that's worth bearing in mind as well. Okay, and the last thing I want to cover on this second topic is easements, because this is what's received a lot of attention. So if these easements, which basically means watering down the law, okay, if a local authority has not triggered these easements, it must stick to the Care Act and fulfill its legal duties. And as I say, there, as far as I know, is only one local authority at the moment, as of today, that has triggered the easements, and that is Solihull Council. So unless you live in Solihull, your local authority has not triggered these easements, and so the Care Act and their legal duties have not been watered down at all. Even in Solihull, these easements are temporary, and they are basically designed to relieve a local authority of some of its legal obligations when, for example, its workforce has been significantly depleted with people self-isolating and so on, which is putting people's lives at risk. So they were introduced as part of the government's response. Anna mentioned the Coronavirus Act in March. This is where the easements were contained. And essentially what they do is water down the law, the legal obligations. So it means the local authority doesn't have to carry out detailed assessments, doesn't have to carry out financial assessments, doesn't have to prepare care and support plans, and in a very extreme case, doesn't even have to meet a person's eligible needs unless not meeting need would breach their human rights. So in essence, it really waters down the law to the very bare bones. I think it was anticipated that these would really be needed if local authority workforces were so depleted that there just weren't enough staff to fulfill the Care Act obligations. Okay, as I say, for every, I think there's 152 local authorities in England and Wales. Other than Solihull, they're all at full capacity. So all local authorities except Solihull must continue to fulfill their duty of care, which includes conducting needs assessments and carers assessments. Don't be told that a local authority cannot do a Care Act assessment because of easements, because unless it's Solihull, that's just not true. Okay, questions? Would anyone like to put their hand up? Anyone got a question on that? Kay, James, do you want to unmute yourself? Kay?
Unmute.
Thank you. Yes, that's it.
I'm sorry, I want to go back to the first part. It's not actually on this second part.
Okay.
But I felt so incensed about this. It's in response to the lady who was saying that the council wouldn't pay for her to have a live-in carer because it would be cheaper to go to a nursing home, or whichever way round. My husband, he's got Alzheimer's. He's in the final stages. He can't really do anything at all, but he doesn't qualify for nursing care. And his care needs his package of care needed to be upped. A social worker who'd been with us for a long time, she said, he's really on the high limit of a number of hours a week, the amount of money. She said, and I've got to tell you that if it goes for to get it increased, they're probably going to say that it'll cost less to be in a nursing home, in a care home or nursing home. Yeah.
Yeah.
I said, fine. You do that. I want the council to be fully aware that this decision should not be made on just a financial assessment, because the thing you cannot assess is the quality of life for him to stay at home rather to go somewhere else. And I had backups from the dementia nurse and the GP to say that it would be detrimental for his health if he went away from me. In fact, such to the point that, in fact, the CBN said, you know, you could be had up for murder, because he does need to stay in the same stable environment. But also, I pointed out, the social services have got a duty to the carer. which is me. And but to have him in a nursing home, care home, would be more stressful for me, because although I'm doing everything from at home, I would then have to travel and everything.
Yeah.
When it came to panel just said, fine, give her what she wants. That was basically what they said. And he is on, we live in a retirement village set of flats. We've got a residential on-site care agency, and we have a tremendous amount of support. If needed, they could be coming in every couple of hours. But what I want to say to the lady that was finding is that you must remember that the council, they just go on money, but there is the quality of life, and also it is the effect on the carer. And to think about that if you have to challenge them on anything.
Yes. Well, thank you, Kay, for those comments. What I would say in terms of legal arguments that you might need in this sort of very common situation, that the first line of attack, as it were, is, as you say, it's a needs-led argument. So arguing that, in fact, it wouldn't meet my spouse's needs to go into a care home for these reasons. And, you know, we all know that moving into a care home can threaten someone's life expectancy. Being in a care home at the moment is far more dangerous than it has been, because, you know, the communal living potentially presents an increased risk of contracting the virus. And you can argue that the person's happiness could be affected by a move. So in terms of the law, your first argument, and sometimes the best one, is that residential care would not meet the person's needs. Because don't forget, under the Care Act, the local authority has to meet the person's needs. And so if you are able to convince them that a care home would not meet their needs, then a care home is not an option. Okay, so that's your first and in some respects the best argument. The second line of argument that I think is worth bearing in mind is that let's imagine that you've tried that first one and you failed, right? So the local authority is saying, no, a care home would meet your husband's needs. Well, if you don't think it would, then there's a dispute. And there's a dispute over best interests. And no local authority can essentially kidnap someone and take them to a care home. So if there is a dispute about whether a care home or staying at home is in the person's best interests, then that dispute must be resolved by a judge. And it's the court of protection that would resolve that dispute. And so that's your second line of attack, by essentially saying, look, I'm assuming you don't have power of attorney, because if you've got power of attorney for health and welfare, then obviously you would decide what's in his best interests. Right?
No, I was too late to get it. The doctor said he hadn't got the capacity.
Okay.
I do everything in his best interests.
Yeah.
And we've got a DNAR, we've got respect, and we have discussions, complete discussions over anything might be needed.
Yeah.
If you need to go into hospital or anything.
Yeah. So I think that the key point is that they can't force you, and they can't force him. So that sort of dispute would have to go to court, and then a judge would weigh up his best interests, your husband's best interests, to decide on his behalf actually what is best, looking at the pros and cons of staying at home versus going into a care home. So I think that that's quite important, that local authorities cannot force someone against their will or against the will of the family without going to the court of protection. So I hope that's useful. Thank you very much, Kate. Hazel, do you want to unmute yourself?
There we go.
That's it.
Thank you. Can I just say, I actually had a reassessment of my needs last week, and they gave me an extra 8 hours funding straight away over the phone. No arguments, no nothing.
Super.
I went from 8 hours direct payment now to 16 hours.
Great.
So it's going to help.
Great.
Yeah.
Okay, thanks for that, Hazel. That's
no
really,
problem. Thank
really
you.
helpful to know. Thank you. Nicola?
Hi, yeah, I was just wondering if you can get the guys to do direct payments, can you use that to cover care that is above the assessed need? Hazel's nodding brilliantly at me. Thank you, Hazel.
What do you mean exactly, Nicola? Because like if I give you, let's say, I don't know, £200 a week to meet the need through a direct payment, are you asking whether I would, as a local authority, give you more to meet needs that are not eligible for services, or?
No, so my mum gets 4 visits a day at present, and we think we've put her on we've requested another assessment because I actually think her needs have increased. What I'm wondering, and we think she needs to go into a care home, what I am wondering is whether if I can persuade them to give me the direct payments, whether I can then accelerate that process to alleviate the burden on me as the carer, get her into the care home, and get her needs assessed slower time, basically make her safe.
Yeah. Well, as I say, it's a needs-led issue. So let's say, for argument's sake, someone has 4 visits a day at home, which costs £800 a week, for argument's sake. But the person's needs now are such as to require residential care, which would cost £1,000 a week. The local authority has to meet that assessed need. So even
it takes a while for them to do that assessment.
It does.
And therefore there's a gap, and I'm just worried about that gap, basically.
Well, it might be, without giving you any advice, it might
Obviously.
be wise. My insurance won't cover it. It might be wise. Have you spoken to the local authority yet?
Yes, absolutely. We're a high priority for having an assessment, but in the interim, we've got to wait for that. You know, there's a physical number of people who can actually do that assessment. Therefore, you've got to kind of wait for them to get through their workload, and other people, you know, priority to flex and all that.
Yeah, it's about battling. Everyone's on a priority, and it's about battling who's the most
exactly.
priority. Yeah, exactly. But that's like obviously you don't want it to get hostile, but obviously sometimes having to raise a complaint speeds up matters.
Yeah.
Okay, thanks, Nicola. I'll just take one more if that's okay. So sorry, Hazel, but put your question in the chat. So Kathy, do you want to unmute yourself? That's it.
Hi.
Hi.
I've got a problem at the moment. My dad's down in Devon and I'm in Essex, quite a distance away from each other. And social care have not been communicating with me. He was admitted into hospital for 3 weeks after he'd caused a fire in his flat. They then spoke to him about going into a care home, and they said that he agreed to go into a care home. I then managed to speak to Dad because he doesn't answer the phone at home. He gets confused. He doesn't understand what the ringing is. So I managed to, I found all this out by accident, you know, through another source. Social care, just despite me keep talking to them, I'm the only child. They don't talk to me. They just make decisions for him. But they said he agreed to go into the care home. I then found out that he was actually it was abuse. He was suffering abuse in there, and I had to make the awful decision to move him, to insist that he be moved during the COVID crisis into another care home and risk contracting COVID, but now happy with the care home he's in. But they keep making decisions without including him. They finally invited me to a best interest meeting last week, a virtual meeting, and he wasn't on that invite. He wasn't invited to join. They were saying he lacks capacity, but there was no clarity on who had completed an MCA for him. So I think it's just the social worker saying he doesn't have capacity rather than a formal MCA. Financial assessment, again, I think it's informal. He's been looking at his bank statements and judging whether he's going, by the time his bills are paid, basically he's going to be less than, is it 23,500?
23,250, yeah.
And yet I've got bills for the care homes, which I don't quite understand. And it's just this communication. And on the one hand, they're saying they're happy for me to get Dad to sign a form so that I become a joint account holder, an additional account holder, so that I can pay these bills for him. But then on the other hand, they're saying he lacks capacity to make decisions in his best interest. And I just find their casual, informal approach to it all staggering.
And do you hold any sort of LPA?
Unfortunately not. And
No.
and this is the thing. And this was what I questioned with them. When they said he lacks capacity, so I can't get an LPA, they were saying that I had to go down the deputyship line.
Yeah.
So they said he lacks capacity, but then they said, yes, get him to sign that form. I said, but if you're saying he lacks capacity, legally, he should not be signing that form to say I can, manage his accounts.
Yeah.
And they said, well, I think in this instance, it will be okay. And I'm just really concerned that
it sounds like it's quite a sloppy use of the Mental Capacity Act, if I can put it that way. Because like in terms of, if someone is unable to decide whether to go into a care home or go home from hospital, the fact that they're willing to go to a care home does not equal agreement. You can't agree to something if you lack capacity to make a big decision like that. So, query whether he had capacity to make that decision. It also sounds as though, again, without giving you any advice, but deputyship, you might be looking at deputyship potentially. So you might need some legal advice around that. The other thing to think about is, and this is where the safeguards could be quite important. There's something called the Deprivation of Liberty Safeguards, or DOLS, as they're called. And this is a sort of classic case when someone should be under DOLS. So you may want to have a chat with them about that, because that would at least ensure that there is, given how far away you are from Devon, if DOLS is used, Deprivation of Liberty Safeguards, then that will involve 2 independent assessors that will basically look at the way in which your father ended up in the care home, so that they will look at that sort of slightly lax approach to the Mental Capacity Act potentially, and you'll get essentially a second opinion.
I mean, I've got to say personally, I feel he is better off in the care home, but it's just the way they're sort of taking control without including him. And sometimes, if it suits them, he has capacity, and other times, if it suits him, he doesn't.
Yeah, and
and that's what worries me.
As we'll see now, we'll move on to best interest now, it's important for them to take into account his wishes and feelings. So at this stage, I'm going to hand over to another of our fabulous students, Eve. Eve, if you're there, to have a quick word about best interests. Over to you, Eve. Eve, can you hear me?
Yes, I can. Can you hear me?
Yep, away you go.
Cool. Sorry about that. Okay, so when someone is deciding on someone else's behalf, it's really important that that decision is made in their best interest. I'm sure you've all heard that term so many times, it's sort of like a buzzword. But it's really important, and it basically involves a decision maker considering all relevant circumstances that that person would consider if they were making the decision themselves. So things like their past and present beliefs, their values, their wishes, and their feelings that would affect their decision from the options available. So things like religious, cultural, social beliefs. And they could be expressed verbally by the person, or they might be expressed through behaviour and habits and choices. And every decision should be thoroughly investigated and decided on an individual basis. So what might be in one person's best interest might not at all be in another person's best interest. So it is very much to do with the individual themselves. A decision maker needs to consult other people who are important in that person's life. So seeking the views of family members and those interested in the person's welfare, like carers or friends. And the assessor needs to weigh up all of these factors really carefully, including the carer's views, to make a decision that ultimately the person would have made themselves. So when they're consulting people like carers or family or friends, it's often a really good opportunity for them to get more of an insight into that person's views. So you probably know the person really well. So if you're aware of their views or whatever, that should really help when being consulted by the decision maker. It gives them an overall view to make sure that they're making the decision as close to what that person would have made themselves. And any decision made should restrict their rights as little as possible. And we use this test to construct a decision similar to what the person might have made if they were deciding for themselves. That's the really important bit. So yeah, thank you, Neil.
Thanks ever so much, Eve. And the key mantra that the students have come up with really to sort of sum up best interests, and to some extent contrary to the question that we've just heard, is whenever someone is making a best interest decision, there should be no decision about me without me. In other words, that as Eve was saying, the person that lacks capacity must be at the very center of the decision. And I think often some health and social care professionals lose sight of that. So thank you very much, Eve. And then we're going to move on to Megan, who's going to talk about a very tricky issue, which is what happens when there are LPAs, but there's a dispute not with professionals, but with the family. So disputing attorneys. Megan, over to you.
Thanks, Neil. So if you've seen in the previous slides, best interest should always be the focus of decision making, but it's not always a simple matter because there can be more than one decision maker, more than one attorney. And if these attorneys disagree with each other and decisions aren't being made, it's very likely that best interest of the person won't be protected. So to resolve these issues, and the first step is pretty much common sense, you should try and make arrangements between the attorneys, come to a decision together about what would be in the best interest. But if this is unsuccessful, you can talk to the Office of the Public Guardian to get some advice, because this is the organisation that's in charge of looking after people who are protecting the rights of people who lack mental capacity. But then in the most extreme scenario, if it's clear that the two attorneys can't work together, the Court of Protection will intervene and cancel the lasting power of attorney. And when they do this, they can then have the opportunity to appoint a deputy, as Neil explained earlier.
Thanks ever so much, Megan. And just to give you an example of how messy things can get, I've got a case at the moment in the Court of Protection where son and daughter were appointed by father under LPAs. They're in dispute, and it's cost £50,000 so far in legal costs to try and sort that sibling rivalry out. So be careful who you choose as your attorney, I would say. Okay, thanks ever so much, Megan. So that was the third area, and I'm conscious of the time, so I'm going to move straight on, if I may, to the fourth area, if I can stop messing about, which is care homes and end-of-life care. So we've kind of touched on this already, but very quickly, in terms of self-funders, apologies. A self-funder is someone who obviously fully funds their own social care, but a local authority must do a financial assessment in advance of that. In the green circle at the bottom there, and this is often a big issue with in the dementia context. In law, bearing in mind that distinction I talked about between social care and healthcare, and how grey it is in the middle, I think dementia falls into that grey zone. It's always worth being aware of what's called NHS continuing healthcare, because if you have dementia and you qualify for NHS continuing healthcare, then the NHS steps in and pays for all of the care that's required. And the legal issue, they'll do like what's called a checklist and a decision support tool. And that process is aimed at trying to work out, is this a social care scenario, or does the person have a primary health need? Because if you're assessed as having a primary health need, then you're entitled to free, regardless of your financial means, free NHS continuing healthcare funding. So that's quite important in practice. I've talked about these thresholds before, so I'm going to skip over this very quickly. For social care, I mentioned that if you've got £23,250 in capital, so that's savings, any property you own, so it's not a lot really. If your wealth is above that amount, then you are a self-funder so far as social care is concerned. You're expected to pay for your own care. If you fall below £14,250, if your wealth is below that, then the local authority must pay for your social care. And if you fall in between the two, then basically there's a contribution made from both parties. Okay, so those are the basic rules to work out whether someone is self-funding at the top end, whether they get free social care at the bottom end, or whether they have to contribute in the middle. I'm going to skip over that. Oh, no, I won't. So self-funders can choose. Obviously, if you've got the money, you can go to whichever care home that's willing to take you, as long as you can afford the cost of it. Sadly, money creates more options in reality. If the local authority is paying or contributing, then you might have less choice. And that's because of what I was saying earlier, that under the Care Act, the local authority must have arrangements to meet the assessed eligible needs, but they can take into account resources when deciding how to meet that person's needs. So in practice, what you often get is local authorities might be happy to pay for care at home, let's say up to 4 visits a day. But if someone's needs are beyond 4 visits a day, then they might be looking at residential care, because the cost is about the same. 4 visits a day at home versus residential care. In many parts of the country, that's almost about the same level. And that's when you get into this dispute sometimes with local authorities. Will they pay for care at home that goes beyond the cost of residential care? And as I was saying earlier, that's when you should focus on the needs argument. Going into a care home might not meet their needs. And failing that, if we're talking about having to move someone against their will, and I've had cases where we know the person with dementia will not be willing to go to a care home. So if it's against their will, or if it's against the will of the family, in those sorts of scenarios, if there's a dispute over best interests, then it must go to the Court of Protection. Okay, so let's then quickly deal with top-ups because we've had a few questions about that. This is basically the difference between what a local authority is willing to pay to meet need versus the cost of, let's say, a care home. So let's imagine a care home costs £800 a week, whereas you've identified a care home that you think is more suitable that would cost £1,000 a week. So you've got a £200 gap per week in funding. In that situation, assuming both care homes would meet the person's need, in that situation, then family members or friends can pay the difference, the £200 a week, to get the preferred care home. So that's what a top-up consists of. One big issue, and I'm very conscious of the time, and I know what Zoom is like in terms of fatigue. So I want to spend a bit of time on this, if I may, because this is a very pressing issue during the course of the pandemic. We've had lots of questions about care homes restricting contact. So I'm going to hand over to Linny, if I may, one of our fabulous students, to talk you through the legal position around maintaining contact with those in residential care. Linny, over to you.
Thank you, Neil. So as Neil has said, contact in care homes has been a really big issue because most care homes have been restricting visits due to COVID-19, and some care homes have banned all visits altogether. And this can be justified by the threat that would otherwise be posed to the lives of those living within the care home. However, they must look to provide you with an alternative form of contact, including virtual contact, such as a phone call. So that's my part. Thank you, guys.
Oh, okay. Thank you, Linny. Yes, like obviously, living in a communal area like a care home can increase the risk of contracting the virus, because once it's in a care home, then it's very likely to spread. And care homes have received government guidance in April, which still needs to be updated. But they've received guidance in April that basically says that they should restrict access, whether that's from the family wanting to come and visit or professionals coming to visit. They should restrict access to only essential visits. And so this has caused a lot of concern because what we're seeing, especially with those with dementia, is some people have literally turned to the wall. They feel as though they're being punished by not being able to see their family, and they've turned to the wall and perhaps died early. Or another common reaction by not being able to see your loved ones is that they become very agitated and challenging in terms of their relationship with the staff, which in extreme cases is leading to medication. So there is definitely, I think, a relationship between restricting contact and life expectancy and distress. Now we've got some hands up here, so before I say any more, I'll take some questions. So I'll take the first question. Yep, you're unmuted, go ahead. I don't know what your name is entirely. UHLAHTA.
Is it? Yeah. All right. Sorry. Yeah, I was going to supplement with the Jane's sort of experience that I was my wife carer for 17 years at home and a respite care home. So we find that it is sort of easier life at home rather than at the care home, whether care home or state provided private care home. And then there is a research from the Martin Knapp from the LSE. He's mentioned about the difference in care home expenses in 2014, 2015. There was about 3,000 difference cheaper at the care home than the own home. But because of my experience for 17 years, 17 6 weeks on, 6 weeks off at the respite home and my own home, our lives are a lot better. Everybody can come and visit, and they're a lot cheaper for us physically, as well as all the emotional things. The friends, family could come easily, but not restricted.
Yeah.
So I make a sort of campaign about the for the dementia care at home in the public places or in the community, that if we can support everybody, all the stakeholders of the dementia care are chipping in equally for the care to keep our loved homes, our loved ones at home.
Yes. Yes.
Then the government will take the general minimum contribution, set up the minimum contribution, but whatever top up is needed, we need to do that. So, I mean, at this present situation too, it is a very important that we keep our loved ones at home, and we won't. If my wife is still alive, I won't let her go to their care home because of so many things and happening, as well as even respite home during that period, 17 years. There were so many transgression.
Yes, thank you. And I think you've touched on what is essentially a common theme, I think, throughout this afternoon, which is that battle to often try and find ways of ensuring that your loved one can stay at home, rather than what is sometimes a cheaper option of going into a care home, because you know, someone's best interests shouldn't be dictated to by what's cheapest. And I've certainly had lots of court of protection cases where these sorts of disputes have gone before a judge. A local authority is saying, look, we can meet this person's needs for this price. And the judge has said, okay, well, will you put that money towards care at home? And a local authority might say, well, we're worried about that because that's not enough care. But we're not willing to pay more. And so sometimes judges have to make that sort of decision, which is when you're weighing up the pros and cons of living at home versus going into residential care, sometimes on balance, judges will keep people in their own home and pick up, because whilst it may or may not be safer, it's where the person is most likely to be happiest. And that's what they're familiar with, which is particularly important in the context.
I think this is of the trend of the dementia sufferers, that they are always happy with their familiar faces.
Absolutely.
And the safety is there for them. It's a safety.
Absolutely.
So even my wife would know the difference between going to the respite home for 6 weeks. She doesn't complain it, but she will be looking forward to coming back to home. So
absolutely,
these are the things that a lot of emotional support is there. That is the whole thing for us.
Yeah, yeah. Thank you ever so much for those really important comments. I'm just going to take another question from Victor. Victor, do you want to unmute yourself? I can take a quick question.
Yes, I did ask it on chat really, and Lisa's asked something about the cost of if you dispute a decision and end up in the court of protection. There's a cost involved in that, is there? And also, while you're waiting for the decision, what happens to your family member? In my case, my mother, who's currently in a halfway home between hospital and the decision.
So, in these sorts of cases where we're talking about welfare disputes, like where is it in someone's best interest to live? Generally, legal aid, in other words, free legal representation, is what's called means tested. So you're right that usually you either have to pay for a lawyer or represent yourself. And the Court of Protection does its best to accommodate people that represent themselves. But that's the sort of general rule. If you've got more than £8,000 to your name, then you won't get free legal representation. However, and it's an important however, if someone is under the deprivation of liberty safeguards that I mentioned before, then that person, so not necessarily a family member, but the person that, let's say, has dementia, as well as their representative, which could be a family member, because everyone under DOLS gets a representative. So the person and their representative does get free legal aid. So that's quite important to know. If there's a DOLS authorization, which means that the local authority has authorized and provided safeguards for the person in the care home or hospital, then there is free legal aid available, regardless of your means. I've had one case involving a millionaire with dementia who was, he'd never married, very stingy with his money. He was a very successful company director before he retired. And he literally had £1.5 million in his current account, would you believe it? And he didn't want to be in a care home, but equally, he was too stingy to pay, well, not stingy, he didn't want to pay for a lawyer to get him home. And he had a home to go to, and he'd been 4 years away from his home. And so when DOLS was used, he was absolutely delighted that he could then get that to court without having to pay for a lawyer. So if there's a DOLS authorization, there's free legal aid available. But that's the only kind of situation in which people would get a free lawyer if they've got more than £8,000. Okay, thank you, Victor. I'll just take one more. Cecilia, do you want to unmute yourself? And then I'll move on to the last topic. Yes.
Hi, good afternoon, everyone. I'm a member of Tide. I'm a very proud member of Tide. Hi, Anna.
Hi, Cecilia.
A couple of points have just been made to all the carers. I'm now an ex-carer, a proud ex-carer, and during our journey, our family's journey with my father, this is really important that everyone hears what I'm about to say. I spent more time fighting my local authority, reading legislation. I was unable to get any funding for any legal advice. I had no money. I was doing my degree for something at the time then. And for the time that I spent fighting nearly burnt me out. In fact, I think it did, emotionally and physically. However, now with Tide and on a Zoom today with all other carers and current carers and maybe some ex-carers, the way forward is for ex-carers and current carers and family members and people who are all sitting around this, this table today, is to go forward and support that we will be listened, we will be heard, and we will be seen. It's so important. The hardest thing that I ever done was trying to read legal documents. I won the direct payments. I got the direct payments increased. I politely, respectfully argued and pulled down my local authority, and I shamed them. And then what I done then is I won then continuous healthcare funds and battle. I shouldn't have needed to have done that. I should have been enjoying the quality time with my wonderful dad. So go forward, and again, Anna, well done. Thank you.
Thank you. Thank you so much, Cecilia. And I can just, essentially echo what you've said, because I know a lot of people on the call today have expressed issues that they wish they'd known about those legal and welfare issues that you've been discussing today at the time when some of you were actually on that journey or at that particular time. So I think this is one of the reasons for the Law for Dementia Carers project, because we do feel very passionately that, you know, despite the massive contribution that you make, those voices and those experiences are not necessarily being heard by policymakers and politicians and commissioners. So it is imperative that we come together and have that collective voice. So that's really important. Also mindful, Neil, of time.
Yeah, I was just going to suggest that the very last topic, which I can cover in literally 2 minutes, but it's an important topic, relates to do not attempt resuscitation notices, because there's been a lot of controversy about.
Could I just ask permission then from the group, for obviously for those people, because we have gone over, and I know we could sit here for hours and talk about the issues that we have got on the table. But obviously, I just want to respectfully say that if anybody does need to leave, and obviously I've seen people mention on the chat that they've got to go to work or feed the family or do anything else, then obviously feel free to opt out at this stage, because we will do the recording, we will do a report from this, and we will pick up all of the questions and comments and links that people have very helpfully shared throughout this webinar. So Neil, I'll hand over to you, but I'm going to try and keep it short and sweet.
It is short and sweet, and the key message really is that if, for example, a GP practice, as we've heard in the news, has been sending out letters, like blanket letters, inviting do not attempt resuscitation notices, then they're completely unlawful. Whenever a doctor is considering whether resuscitation is necessary or not, and this is the key point, it's absolutely critical, and it's a significant human rights issue. It's absolutely critical that they discuss this issue with the person if they've got capacity, or more likely, if the person lacks capacity, it's critical that they discuss this issue with their carers and those that are interested in their welfare, so that a joint decision about resuscitation has been reached. And obviously, given what's at stake with these sorts of decisions, it's imperative that carers are properly consulted about the person's best interests. So that was the last message, and we've covered all 4 topics, which I hope was helpful. So Ada, back over to you.
Wow. Oh, sorry. Yes, wow, indeed. My goodness me, it has been a phenomenal webinar. So thank you all so much for your patience and your contributions to the whole conversation. In terms of next steps, as I should have said at the beginning, we are recording it. I think Lena and Rebecca have scripted that in the chat box, but we are recording it for 2 purposes, really. We've been inundated with requests for more information about this. So obviously, the primary purpose for holding it and recording it is to do a report at the end of this webinar that can be shared on the Tide link, or the Tide website, and others. We'll also be in a position where we would like you to sign up to Tide, because what we want to do is to keep this conversation alive and growing, and in particular throughout the whole COVID-19 scenario, and in particular where Neil mentioned around the Care Act easements and some of the issues that you're facing at the moment from local authorities and others that are not to submit that as part of the government 6-month planned review. We haven't got any clarity from the government at the moment as to how they'll manage that process in terms of information going into the government, but we're committed to actually collating that. So do please keep in touch. The other thing that I would want to say is that obviously this is an ongoing project and there's lots of issues that's come up today. So I would like you to join Tide. We will want to hopefully keep in touch with you as we move forward with the Law for Dementia Carers project over the next 18 months. The first part of it is to look at training and awareness raising for you as carers and former carers, and to co-produce, if you want, or work with you to produce that training. And the second year is about focusing and ensuring that frontline staff, because as you have all witnessed today, frontline staff, and in particular primary care staff and social care staff, really don't necessarily know either the full extent of your rights and legal rights and welfare rights. So it's a two-pronged approach. It is different, and it is innovative. It's the only one that's focused on dementia carers nationally. And in particular, the final thing I'd like to say is I'd like to say a huge thank you to Neil and to all his students from this week, because I think you've done a sterling job, Neil, in bringing all of this together. And my apologies for going over time, but it has been a phenomenal success. And I'd also like to thank Peter and Catherine and Phil, if you're still with us, Phil, and Roger, who is contributing to the steering group, and also obviously to Karen, who's got a tremendous amount of work done behind the scenes to make this webinar happen. So I think that's all from me, but I really hope that you've enjoyed it and found it interesting. And do, like I said, please stay in touch. We'll email out the report and the video. So thank you very much, everybody.